Okay, I'm ready. Ready? Oh. Okay. Yep. Oh. Ready? Let's go.
Please rise. 34th District Court is back in session. I'm Tina Brooks Green presiding.
Have a seat. Do we have,
She's next door with me.
will you get, Ms. DeMott Grady?
Go ahead, sir.
Calling People versus Brian Gilson.
Morning, Your Honor.
Good morning, Your Honor. Larry King, P78774, on behalf of the people.
And good morning, Your Honor. Neighborhood Defender Service by Kate DeMott Grady, P83667, on behalf of Mr. Brian Gilson. Mr. Gilson, can you state your name?
Brian Edward Gilson II.
And Mr. Gilson, when you have a seat, you can take off your masks if you want. We're all appropriately social distanced. Obviously, if you move or whatever, when you get up, you got to put it back on. But while you're seated, you're fine. Are people ready to call their first witness?
Yes, Your Honor. I will state for the record, the complaining witness, the Sarah Forbush, is not present. We did send a couple of subpoenas to at known addresses for her. The subpoenas did come back as served by the Postal Service as certified mail. However, they didn't bear any signature except the letters CV19 or COVID-19. So it's unknown to us if she actually received those subpoenas. I do have Officer Bryce Moon here, who is the responding officer, and I intend to proceed under MCL 768.
Did you file the notice?
I did not file a notice, and again, we've had this discussion, Your Honor. The
Oh,
notice
the
I
issue
state-
of the exam versus
Trial.
trial. And what did I do last time? Did I let you do it, or did I rule? Pardon?
Because you did, Your Honor, and I will point out to the fact the statute states it's a.
Actually, was it with you?
I believe it was Elizabeth Young.
Yeah.
You're right, it was with Elizabeth Young.
And the statute states, the
At trial.
evidence is admissible at evidentiary hearing or at trial. The courts have ruled the preliminary exam to be an evidentiary hearing for purposes of the statute in the only case, and the notice requirement in the statute explicitly only applies to trial.
Mr. Matt
And Your Honor, we object for multiple reasons. I understand that under the statute, this is allowed to come in. Again, we cannot assess credibility. You, as the fact finder, or as the assessor of testimony, cannot assess credibility. Confrontation clause, I understand that it doesn't apply here. However, we can't effectively cross-examine this officer as to what the complainant is saying. Additionally, Your Honor, at this time, my investigator actually has a different phone number than APA King has had. I just provided it literally a minute before you took the bench. He has tried her once. I'm wondering if we could adjourn this for maybe a week and get clarity on whether she's even wanting to proceed. If this case is bound over, Mr. Gilson, and decides to take it to trial to exercise his rights, he's looking at a trial in 2022 or 2023, given the fact that jury trials are shut down right now. So this bind over has very big implications and long-lasting implications.
Mr. King, response?
Well, I will state that yes, Mr. Montgrady's investigator had a different phone number. She provided that to me, and I have only had a chance to try it once.
I just am wondering if there's what's the negative to the people if I move it to the December 1st date?
I have no problem with an adjournment. Officer Moon, are you available? You don't have a vacation coming up?
No.
Then I don't think there's going to be a
Because
problem.
I have a docket with you I have one on November the 10th, but I'm not putting anything else there.
If
You
Mr.
have
Montgrady and her
birthday.
client
Oh.
are
I would do
okay,
that.
because that would put us outside the timeliness requirements, obviously. But if Ms. Demott Grady and her client are okay
The
with
time limits. Did you really just say the time limits
the
during this
timeliness
stuff?
requirement.
The timeliness requirements during COVID,
I
all
know.
bets are off. Talk to downtown about the timeliness
Mr.
requirements.
Gilson will waive his right.
That's what I needed to be
If that's
heard,
what
yeah.
you needed to hear.
So, if the court is more inclined to adjourn this, then that's fine with the people. The people would be fine with an adjournment. And during that time, we will make additional attempts to secure the testimony of Ms. Forbush.
I'll adjourn it to the December 1st date at 10 o'clock.
Ms. Demott Grady, did you want me to explore the potential of pre-exam settlement as well?
I think I would like clarity on whether the complainant even wants to proceed with this case. So
Okay.
let's work on that, but we've got plenty of time to negotiate. and
Wonderful.
see if that's what we're gonna do.
Wonderful. Then nothing further. Thank you, Your Honor.
Thank you, Your Honor.
All right, I'm adjourning it to December the 1st at 10 a.m.
Appreciate that. Thank you, Your Honor.
Thank you, you're all set.
Thank you, be well.
Thank you, Your Honor.
You're welcome. Let me know on your bench trial.
Yes, I will let you know.
Thank you. We have 3 matters left, Paula. Thanks.
You're welcome. You already did the civil hearing?
I didn't, I got them on right now.
Oh, okay. And you don't want that recorded?
Nope,
Okay.
thanks.
Holler when you need me.
I will, thank you. On the Rev L4, can I get a last name? Hello? Paige, do we have any idea who this person is?
I don't know who it is, Judge, but